argued in respect of the Safa respondents. However, my lord, I must put it on record that it is the duty of the council to otherwise, and that's what I'm proposing to do. And during our submissions, we're going to demonstrate that what has been argued by the Safa respondents is an outdated law. We will provide you with a correct law that you should apply in this matter. And I must say from the beginning that you must hear this matter because this court has jurisdiction. And where credit is due, I will give credits to the Safa respondents, where they've assisted the court, where they've assisted us in terms of minimizing the issues. The first point that I'm going to give credit to the Safa respondents is that they understand that we are coming to this court on the basis that there is a decision that they took on the 2nd of July. And that is the basis that we are in court, and we are in court to challenge that decision. And what I must also give credits on the Safa respondents is that they understand our challenge to be in terms of purge. So what we are required to do as applicants, we must show the court that the court has jurisdiction to hear this matter. And what I must say up front as being outdated law, where I will after provide the correct law on the proposition, it can be understood and it appears on the Safa respondents that their challenge is purely based on Section 21 of the Supreme Court Act. My lord, that's no longer the position in administrative action. They also rely on the old judgment of 2006 from Western Cape. There are 2 judgments from the SCA which have provided an exclusive jurisdiction for administrative action. And what I must demonstrate, because now I've proven to the court that the 2 points that were being a cornerstone relied upon by the Safa respondents are no longer the law, are outdated, to show the court what are the grounds that one needs to prove when you come to court, and to show to the court that we have met 1 or 2 of those grounds. Therefore, that gives this court a jurisdiction to entertain this matter. Because when we look at those grounds, the court should not consider all the grounds that are listed. 1 ground is sufficient to engage the jurisdiction of this court. My lord, I will provide 2 judgments from the SCA. It's a 2019 judgment and 2022 judgments. My lord, I will start with the 2019 judgment, which is the judgment of Director General of the Department of Home Affairs and others versus the Saudi attorneys and another. I will request the court to look at paragraph 37 of the judgment. And my lord, while I'm still on this point, you were told that there is no jurisdiction that is found on the basis of PAJA, or there are no provided specific grounds for a PAJA review. My lord, at that point you must not accept, because as we look at paragraph 37 of this judgment, it shows that there are certain jurisdictions that are exclusive for an administrative action, and we are coming to court purely based on that. My lord, paragraph 37 of the judgment says, the application brought by the respondents in the court below was heard by Ali J. In relation to the question of jurisdiction, she had regard to the submission on behalf of the appellants that in terms of Section 6(1) of the Promotion of Administrative Justice Act 3 of 2000 Paja, read with the definition of court in that legislation, there were only 4 grounds on which a court would have jurisdiction, and that those grounds were lacking. In respect of the application before the court, the following in terms of that legislation are the basis for the exercise of jurisdiction by a competent court. The court in whose jurisdiction the administrative action occurred. In the present matter, we will accept that the decision was taken in Gauteng. So one of the courts in Gauteng, either the Joburg High Court or the Pretoria High Court, will have the jurisdiction to entertain the matter. The second ground, the court in whose principal place of business administration is within its jurisdiction. Even on this, we won't take an issue about the address of the respondents. 3, the court where the adverse affected parties is domiciled. While I'm on this third ground, the court would accept that it's admitted. In fact, it was part of the argument of Safa respondents that we are coming to court on the basis that Sinenkani is from Eastern Cape, therefore this court can entertain this matter. It appears under those 4 grounds that we are entitled to come to this court. Then under the 4 grounds. Because that's where Sinenkani is domiciled, is within the Eastern Cape, there in Pizani.
So I don't want to misunderstand you, Mr. Kong. Are you saying on all the 4 grounds stated there, Sinenkani qualifies on each of those?
No.
Or are you saying I'm relying on 10.3? I'm domiciled in the Eastern Cape, it's common cause, and based on that 10.3, this court would have jurisdiction.
My Lord, out of the 4, we meet the last 2. Whether this court can say, based on 10.3, I accept that Sinenkani is within Eastern Cape. That is sufficient for this court to have jurisdiction. Whether we go to 10.4, that says the court where the adverse effected of the administrative action will be experienced. Because these parties are here in the Eastern Cape. They will experience the exclusion in the Eastern Cape, not where the playoffs are taking place. Then, my Lord, while I'm still on that point, if I may request that we go to the second judgment, to paragraph 14. From the SCA again, not from the High Court, but from the SCA, which is binding to this court. Paragraph 14 says, the judgment is the judgment of it's TMT Services and Suppliers Pty Ltd, taken care of Traffic Management Technologies versus MEC Department of Transport, Province of KwaZulu-Natal and others, case number 1059/2020, open brackets 2022, close brackets, ZA SCA 27, 15 March 2022. My Lord, in this judgment, I would request that we go to paragraph 14. In the case of review proceedings in a high court, as in this matter, the following courts have jurisdiction. The High Court, within whose area of jurisdiction the administrative action occurred. The High Court, within whose area of jurisdiction the administrator who took the administrative action has the principal place of administration. C, the High Court, within whose area of jurisdiction the person whose rights have been affected by the administrative action is domiciled or ordinarily resident. D, the High Court, within whose area of jurisdiction the adverse effect of the administrative action was or will be experienced. My Lord, it has been considered during argument that Sinenkani at least is within or is a resident within the Eastern Cape. Therefore, we are entitled to come to court. So it has been proven in this judgment that at least on that ground, I understand on the last ground, as much as we say it fits perfectly in terms of what is happening in the matter, they may argue different, then it might be a question of interpretation. But at least on C, without any need of a further interpretation, this court can accept that it has jurisdiction to entertain the matter, because the parties that are being affected by an administrative action are resident within this court's jurisdiction. Here in the Eastern Cape. So, my Lord, as we propose to convince the court that what has been argued, it's an outdated law, it's no longer the law, the court, that's how it should accept. In fact, in these two judgments, the first judgment, Section 21, was never considered, but on the second judgment, Section 21 was considered, and the court came to a conclusion that when it comes to an administrative action, it has an exclusive jurisdiction that must be considered when a party is approaching the court. In fact, if I may take the court to a paragraph where Section 21 is considered, it's paragraph 17 of the judgment, which is the second judgment. I will start at 15. Where it says, it was argued on behalf of the respondents that Section 1 of PATA must be read with Section 21, subsection 1 of the Supreme Court Act 10 of 2013. This section provides a division has jurisdiction over all persons residing or being in and in relation to all causes arising and all offenses tribal within its area of jurisdiction and all other matters of which it may, according to law, take cognizance and has the power, A, to hear and determine appeals from all magistrate courts within its area of jurisdiction, B, to review the proceedings of all such courts, C, in its discretion and at the instance of any interested person, to inquire into and determine any existing, future, or contingent right or obligation, notwithstanding that such person cannot claim any relief or consequential upon determination. Then paragraph 16. 4 issues will be discussed below. There are ambit and effect of its definition of a court in the PATA, the principles that apply when more than one court has jurisdiction, whether an abuse of process was committed by TMT when it instituted its review application in the Western Cape Court, and whether Section 6 of PATA vests a discretion in a court to decline to exercise jurisdiction to review administrative action. My Lord, because I don't want to take much time, but we can go to paragraph, I think it's 28 to 32, where the point is also made clear. Then we can also go to the conclusion, where it will be clear that this is an administrative action that was taken in KZN. The application was brought in Cape Town, and then the SCA accepted that that was a correct approach, having considered those 4 grounds of exclusive jurisdiction for an administrative action, not those that are provided under Section 21. It's paragraph 28 to 34. Then, as a matter of completeness, I will go to paragraph 41, which I will read it on record to complete the point. Paragraph 41 says, as the Western Cape Court had jurisdiction and had no power to decline to exercise that jurisdiction, the appeal must succeed. Neither the remaining points in limine or the merits of the review have been determined. The matter must therefore be remitted to the High Court so that the application can be concluded. So what had happened in the Western Cape, it's what they want to happen in this court, where you will dismiss our application on the basis that you don't have the jurisdiction. In fact, in this judgment, it's settled that that's not a correct approach to be followed, especially if we accept that we are dealing with an administrative action, and that an administrative action has 4 jurisdictional grounds. Therefore, those grounds must be considered in order to ascertain the jurisdiction. And one of the points that we can establish without any debate or interpretation is that the teams that are being affected are domicile or resident of Eastern Cape, which is its point C out of those 4 points. Because, I mean, even when we look further, in terms of D, we also qualify because we are experiencing the adverse effect of the exclusion in the Eastern Cape, not in Pretoria. In Pretoria, it's where the playoffs are taking place. But we experience the exclusion in the Eastern Cape, because it's even clear how it's framed on this decision that teams from Eastern Cape are excluded to participate on the national playoffs. Where are those teams based or situated or domiciled? They are domiciled in the Eastern Cape.
You would be aware that in our law, that has a specific meaning. Would you assist me to show that what we are dealing with in this case is administrative action as defined in law?
But in terms of what appears under Section 1 of HAJA, we accept that this is an administrative action. In fact, there is also a judgment which dealt with the powers of Safa when they take their decisions, because the debate in that judgment, which is the judgment of Ndoro from Johannesburg, whether when Safa is taking their decisions, whether those decisions are decisions which are liable to be reviewed in terms of PAJA. The court in that judgment said when officials of SAFA or administrators that are appointed to decide on arbitrations, they are exercising that right in terms of the SAFA statute, which is confined with the Constitution. Therefore, it is an administrative action. In terms of the judgment of Ndoro, I will give the court the citation and the correct paragraph in which Judge Underhold dealt with this issue. In fact, I will read it on record.
Paragraph?
it's paragraph 29 and 30 of Ndoro judgment. The citation of the judgment is Ndoro and another versus South African Football Association and others. Open brackets 16/16836 close brackets 2018 ZA GP JH
Just take it slowly. 2018.
yes ma'am ZA GP JHC 74 2018
And the
3
date on which it was delivered.
it was delivered on the 24 April 2018.
Thank you.
In that judgment, the important paragraphs, it's paragraph 29 and 30, where the court said, these bodies, in brackets, FIFA, Safa, and NSL, open brackets, constitute an institutional framework within which a comprehensive scheme of regulations is administered and enforced. Each entity is a private organization. Neither the entities nor their rules derived from public statutes. These associations and their relationships with their members are found upon contracts. But for all this, a general matter is hard to escape with the conclusion that these bodies do, and these objects, they strive after a public in nature. So after a public in nature, first the regulatory scheme constituted by the statute and regulations is exclusive, comprehensive, compulsory, and cohesive. There is no other way to conduct professional football save in compliance with the regulatory scheme. FIFA and its program are singular source of professional football regulation. Second, compliance is not optional and the rules are backed by coercive sanction. Third, although many actors participate in football for great private reward, football is not the sum of these private actions. Rather, a sport so widely enjoyed and passionately engaged by the large section of the public that the flourishing of the game is a public good and one that is often understood to be bound by with well-being of the nation. In my view, therefore, FIFA, Safa, and NSL, though private associations, enjoy regulatory powers that discharge public function, and when they do so, their actions amount to administrative action undertaken by juristic person in terms of the empowering provisions of their statutes and regulations. This renders such actions open to scrutiny by way of judicial review and apart. So, I think this paragraph 33 of the judgment of Ndoro answers the question that the court has asked. And to take this point further,
you say paragraph 33, I'm sorry.
Yes, paragraph 33 of the judgment of Ndoro.
Thank you.
In addition to that, because we must ask ourselves as to if we say the decision that is in question, it's one of administrative action, which the person who took the decision relied on the empowering provisions as to which statute that was engaged in terms of their own laws. It's explained in the answering affidavit, even though it does not appear in the decision, that we are challenging, that they took the decision relying under Rule 25(4) in order to take the decision to exclude the teams from Eastern Cape. Malot, if the court may bear with me to find that paragraph in the answering affidavit, it's page 133, paragraph 71, where Safa...
Of your own application?
Yes, our own application, yes, Malot.
Yes.
It's paragraph 71 that says, accordingly, in terms of the uniform competition rules and having taken consideration the other affected parties, such as sponsors, other teams in the competition, that a new season would have commenced in August 2025, and for purposes of protecting the integrity of the competition, a decision was arrived at in terms of Rule 25(4) of the competition rules, and it was resolved that the competition will continue with registered 7 teams, excluding any team from Limpopo and Eastern Cape, as their disputes are not likely to be concluded before the end of the national playoffs. So now we are being told as to which statute that was used when a decision was taken. And I must, while I'm on this point, to say how they are doing it to provide a decision without justification of the decision. Then after we file the papers in court, there is an explanation. It's a different issue that we will deal or will challenge when we deal with the merits of the matter. But at this point, what I was demonstrating to the court was simply to say it's not correct that this court has no jurisdiction. And it is admitted by the Safa respondents that what is in question, it is an administrative action that is reviewable under PAT. Even in that, there is no dispute. I was just demonstrating that in terms of Section 1, we meet the requirements. Then in terms of the authority that has settled the point, it's also clear on the statute that when Safa is taking its own decisions, that amounts to an administrative action.
Yeah. But you are still relying on C and D.
Yes, ma'am. Whether you accept C or you accept D, we submit that one of the two is sufficient to establish the jurisdiction of this court.
No, the reason I raised the administrative issue is because my understanding is it's referred to administrative action specifically in A. But my point, I accept it. If it's a review under PAJA, with the authorities are now clear, because PAJA is codification of common law and all that, all reviews are now under PAJA. So if you are bringing the review under PAJA, it's common cause, whether you are relying on C or D, you are entitled to rely on these two authorities.
Yes, because in fact, as a starting point, even to get to A, B, C, D, the top part, it must be an administrative action. The minute you can, you can show or prove to the court that I have a decision that falls within within the definition of Section 1 of PAJA. Therefore, these are the 4 jurisdictional factors that I must rely one of them in order to establish jurisdiction of the court.
Yeah.
Malot, unless there is a question from the court, the other points that have been raised, I will not deal with those, as I have demonstrated that the Safa argument was misdirected, was motivated by old law that is no longer applicable. In fact, for a better word, it was misplaced, because that's not the case that they were supposed to answer, especially after having read the papers, saw what we rely upon, and understood our cause of action. but because they didn't want to make a research and look at what is updated, because that's what we complain about, because that's where they would have discovered that, in fact, to rely on Section 21, it's no longer the correct approach. But they must
stick to the law.
my apologies.
Sorry.
My apologies, my lord. Those are the submissions of the applicant as a conclusion.
Mr. Scopey from FC Rivals.
I see that Mr. Shanti wanted to take the data before me.
Is he not for a respondent?
No, he's for one of the applicants, but I'm just saying, I've noted that he wanted to snatch the paper. And
It may in fact,
I think it's because,
it may in fact be correct.
I think because it's very
Mr. Shanti, you've been joined as
Second applicant, my lord.
in 2013.
No, on the 3011.
That's what I want to say, sorry. In 2011,
Yes,
in Sinenkani's application.
that is so.
You are correct, you are next.
As the copies. My lord, the advent of democracy in 1994 brought about some changes in the jurisprudence. I'm glad that our colleagues for Safa have made certain concessions, as mentioned by my colleague for Sinenkani, the first applicant. Some of those changes, my lord, is the PAJA, the Promotion of Administrative Justice Act of 2000, which in 2004, there is a case of Batosta, a constitutional case which is cited in paragraph 7 of the TMT case that has been handed up from the SAA. That would be in paragraph 7. It's cited there. I would like to refer the court to page 5, that is still in paragraph 7, page 5, where it says, in that constitutional court judgment, which was in 2004, because of action for the judicial review of administrative action now ordinarily arises from PAJA, not from the common law as in the past. Indeed, my lord, this is PAJA, and this was way back in 2004. This is just to indicate the correct stance that has been taken by the first applicant being Sinenkani. And in relation to the arguments relating to Kagama's Juventus, as led by Safa, I'll submit, my lord, that as for the case of Juventus, coming to this court is what we call litigation discipline. It was not ideal for Juventus to either go to the Northern Cape or even Gauteng, for that matter, and make an urgent application whilst it's alive to the fact that there is this urgent application here in the Eastern Cape. So that's basically what informed that applicant coming to this court. And of course, that is also informed by ensuring that the risk is minimized. That is the risk of having conflicting judgments. It's in fact, my lord, something that should actually be commended by Safa, that they are here in one place, their resources are not stressed, we don't have a matter that is in Gauteng or Northern Cape, So that is basically the main reason why you're here. We understand that perhaps that is also to a certain extent contingent on the jurisdiction as argued by the Sinenkani, which we submit that indeed they are correct in their position.
You support the submissions made by Sinenkani and join in this?
That is so.
Thank you. Nothing further
Nothing.
beyond
It's good to see.
Yes, Mr. Scotty.
First of all, the reliance is going to be placed much stronger on the ADR submissions made by Leonard Fan for Sinenkani, and that is exactly how we put jurisdiction in paragraph 19 of our papers, that the effects of that decision are felt in the Eastern Cape. My Lord, without wasting the court's time, His Lordship will actually understand that the basis upon which jurisdiction was resisted is for us, as they allege, for us for lacking to use section 21, and that's how I understand the argument of the respondent. If I may refer His Lordship in the judgment that which His Lordship has already been given, which is the traffic management technologies, particularly at paragraph 28. Important one-liner, which is the second sentence. Maybe let me read into the right one. Where His Lordship has found it. I conclude, therefore, that in order to decide which High Court has jurisdiction in a review of administrative action in terms of purger, you know very well what the law says in as far as the administrative action is concerned. And then, comma, the complete and exclusive answer is to be found in the definition of a court in section 1. But importantly, the second sentence goes, section 21(1) of the Superior Court has no application. So, my Lord, in the entire submissions that were made by my great friend, the SCA decision takes effect that you cannot resist it by section 21. Section 21, therefore, does not apply. And we do outline in our papers, my Lord, that the reason why we're coming here is because of the effects of the decision that were taken in Joburg, that we understand. But we felt those effects here, that is what it is. Thank you.
Thank you. Mr. Dlamini from Thames.
As a position, my Lord, I think I was supposed to have come after my colleague, but it's fine because
The reason for that being?
I was the 7th respondent, but I'll take the opportunities now.
Have you taken the point that this court has no jurisdiction?
Yes.
You are taking that point?
No, we have in our papers.
I've not noticed it.
Okay.
Take me to your papers. Let me
just.
have a look at your papers.
In fact, we just dealt with it. We dealt with it in our heads. My Lord is correct. We dealt with it in our heads. Yes.
It's in the head. You have not made the point in the
Yeah, in the head. Yes. That's correct.
No, that's fine.
Yes, but does my Lord want
You
to
still
address
have
me?
the floor. Address me.
Okay. I think mine would be a very simple one in terms of the address. If my Lord goes to our heads of argument,
Yes.
I just want to take you because what you are dealing with over and above the section 21, over and above the question of jurisdiction, you are dealing with parties which are members of an association. I want to take your Lord to my heads. It's not paginated, but the Ndoro judgment that they referred you to, it's there.
You deal with this point from paragraph 18.
Yes.
Oh,
No, I deal with it, yes, yes, I deal with it from, the jurisdiction, I deal with it from paragraph 12 of the heads. Is my lord with me?
No, not yet. Sorry.
Oh.
Please bear with me.
No problem.
The papers are all loose here and scrambling around. You say you start from paragraph 12.
That's where the jurisdictional point is. But where I want to take my lord,
Just a moment. Yes, finally the where you say the competition taking place in Gauteng is regulated amongst others.
yes,
On the page.
yes. But what I want, if you look at pages 1, 2, 3 pages, then the oral judgment starts there, which you were referred to by my learned colleague for the first respondent.
Yes.
So in terms of that particular judgment, I want to take your lordship to the paragraphs that my learned colleague has referred you to.
Which paragraphs are those?
On the
May you
Juro,
refer to them?
on the Juro, you refer to paragraph 28 up to 34.
Yes.
Yes. So I want to refer you to 30 in particular on the Juro judgment.
I'm waiting.
So at page 30, my lord, what they are saying there becomes very critical in terms of, so what you are sitting with, you are probably sitting with what one would assume to be a tie, in that the applicant say that you've got jurisdiction based on the 2 cases and C in particular because the effect happened in this province. That's the one thing. The second one is to say that jurisdiction in terms of the respondent, or they are saying that it must be in Gauteng. But I want to take you to 30, and let's read 30, which will probably then break the tie. It reads as follows. But for all this, as a general matter, it is hard to escape the conclusion that these bodies do, and the object they strive are public in nature. Firstly, the regulatory scheme constituted by the statutes and the regulation is exclusive, comprehensive, compulsory, and cohesive. So essentially, when you look at that, if you have to determine jurisdiction, the head office of the South African Football Association is in Gauteng. So it is cohesive, and if you are to take it further, it's voluntary association, and they have volunteered and they have agreed to say there is a scheme which we want to follow, and in terms of that scheme, we are saying that we are going to adhere to it. So when you look at 30, then it goes further and it says the following. There is no other way to conduct professional football, save in compliance with the regulatory scheme. FIFA and its progeny are the singular source of professional football. Second, compliance is not optional, and the rules are backed by cohesive sanctions. So there is no option. They've got to go to Joburg in terms of jurisdiction.
It's stated in the Ndoro judgment, the very same judgment that they want to rely.
Oh,
Third.
yes, you are misunderstanding the judgment.
Okay.
These points on paragraph 30,
Yes.
the learned judge is saying why are actions by Safa administrative
Yes.
actions?
Yes. But
He is not dealing with jurisdiction.
okay.
He is dealing there with whether Safa, it's a company, PTY Ltd, is this contract, or
Yes.
is it admin law, that sort of thing. Then the learned judge on paragraph 30
Yes.
gives reasons why he is of the view that though Safa, it's a private association, it's a private company, its actions constitute administrative action.
Yes.
You will see that on paragraph 31, where he says, once this is so, which is all that is in paragraph 30, private associations that regulate football exercise public functions because they oversee a public good and do not simply regulate private interests. You see?
Yes. Yes.
So
I'm
he's
with you.
saying, though this is a private association,
Yes.
which ordinarily would not be taking administrative actions, the actions of a private association vis-a-vis its members,
Yes.
that is a private affair. He now says, because of these reasons he's given in paragraph 30, it goes beyond being a private affair to being administrative action.
In nature.
I understand it
Yes. That's
to
right.
be
No, I do agree.
what the court is saying.
Okay, madam. I do agree. I think, but the final point that I wanted to say relates to, I think on jurisdiction, we say that as much as the effects were felt at this province, we say that at best, of the four grounds, one of them really points to the situation whereby you've got to follow where the course of action happened. So those are submission.
I'm sorry?
Isn't it that you have referred to one of the judgments which talks to 4 points?
Yeah.
Yes. One of the points is to say that you must go in terms of jurisdiction to where the course of action took place.
Yeah.
Yes. So we say that also on that it has to be considered when you determine this matter in terms of jurisdiction to say the correct jurisdiction in the circumstances would be Gauteng, either of the two courts. Those are submission.
I understand if requirements for a particular act or establishing jurisdiction, whatever, have the word "and,"
Yes.
it means we must satisfy all four requirements.
Yes. Yes.
But if it's stated, these are the four requirements, and they are just listed, A to D, without an end,
Yes.
it means whichever of the four you qualify, then you will qualify. That's a point made by Mr. Vori,
Yes.
that
No.
any one of the four is
Maybe
sufficient.
qualified.
You appear to be challenging that.
No. I'm not appearing to be challenging that. What I'm addressing the Lordship on is to say, of the four, obviously he says he is qualifying on one, any of the four. And at the end of the day, but even when you look at it in terms of the law that was quoted by my learned colleague in terms of for the applicant, they are saying that besides 24, because the four also include where the course of action took place.
He's not relying on that, Mr. Vori.
Yeah, he's not. No, I'm not saying that. I'm saying my learned colleague for
Safa.
Safa. Yes.
But he is relying on a completely different statute. He's relying on Section 21 of the Superior Court Act.
Yes, my lord. My lord, let's read it like this. I think I'll explain to you. You have the Section 21 of the Superior Court Act. Then, as you correctly set it up, you then have the four other situations which you're saying that if it has end, then you take any of the two, any of the four. I'm with you in terms of that. And I'm saying, but further, obviously, of the 4, there's one that talks about the question of jurisdiction based on a course of action. Yes, so I'm saying that either you take any of the 4, but even A in terms of the course of action, the respondent or the Safa still will qualify for A, not for probably for C. And my learned colleague, Mr. Bobby, says they qualify for C or D either way. So that's my submission in terms of that.
I'll be honest, I'm struggling with it, but let's leave it at that.
Yeah. Anything that I might assist the court on?
No, you have explained yourself.
Oh.
It's me who's
Okay.
not understanding. I take it that, as you correctly have pointed out, you also are taking the jurisdiction point. You've addressed me both primarily and in reply to what Mr. Fobi and what Mr. Scotty have said.
Yes.
So you are satisfied you are finished?
Yes, that's correct.
I'm sorry I didn't ask you earlier,
No.
immediately after the Safa submissions.
That's my submission.
Thank you. Mr. Mabasu?
My Lord, just one point. Yes, seeing that my learned friend for the interveners unfortunately was not given an opportunity of addressing his lordship earlier on, when Mr. Mabasu was taking that gun, you ought to have responded in his submissions. I understand that things happened in reverse, but I think it would be prudent that we also factor in, because, we factor our responses on the submissions made.
But do they affect what
They-
you and Mr. Vobi?
No, I'm just
Rely on.
raising this. I know for a fact that, based on what is said, the legal position still stands, and as far as the case laws we've submitted is the case. I just wanted to highlight that. Maybe Mr. Vobi may have something to say in response. I do not know, but I was just opening that up.
Is it worthy of a response? That's what I'm
It's
raising
not.
with you.
For me, it's not.
So it's fine. Mr. Vobi wishes to, he'll speak for himself. I take your point. Procedurally, if you had something to say, you would say, may I raise this? But you have nothing to raise. Mr. Vobi has not reason to say anything. These are SA decisions that Mr. Vobi has referred me to. It's not an interpretation
No,
of
my lord.
Section 21.
Understand.
I
very
take your
well.
point
Yes.
procedurally.
Thank you, my lord.
My Lord, we are not saying anything remaining to what we have argued.
Yes, thank you.
As well.
Mr. Mabaso?
As a court pleases, my lord, we stand by our submissions in relation to Sinenkani and FC Ravens. As far as Gagamas is concerned, I just have one point, and that's to say litigation discipline and avoidance of an attempt to avoid conflicting judgments is not grounds for jurisdiction. Not without conceding that Sinenkani and Ravens have jurisdiction. Well, the court has jurisdiction to hear the matter in respect of those two parties. I'm not sure if it extends to Ravens, because on the basis of the authorities upon which they rely, C of those requirements in particular, it doesn't apply to Kakamas. Those are my
It
submissions.
doesn't apply to?
Kakamas Juventus. Just the last thing on that point, my lord. Kakamas Juventus is
Domiciled in the Northern Cape.
correct, my lord.
Just assist me with one thing. The ruling I've just made says Kakamas Juventus is the 7th respondent in case number 3011 of 2025. Is that my ruling? Am I correct in that?
I don't. No, man, 3011 is.
3011, we are the 7th respondent.
Just a moment. I'm sorry. I'm mixing up names. I'm names.
May I assist, my lord?
Yes.
On 3011, Karamas Juventus is the second applicant. It's copies.
I just want to follow what Mr. Mabaso is saying. Mr. Mabaso, let's take this step by step so that it's clear exactly what are we dealing with. On the TMT services judgment of the SCA, on paragraph 28, Mr. Vobi pointed me to where the Leonard Plaskett JA says, Section 21, subsection 1 of the Superior Courts Act has no application. Are you with me?
I'm with you, my lord. I'm correct.
The judgment that you referred me to, you are relying on the National Arts Council judgment. It's a judgment of the Western Cape High Court.
I take that point.
So, even if I am persuaded by that judgment of the Western Cape High Court, the way I understand it, I am bound by the TMT services.
You're bound by it.
So, if I am bound by the TMT services, Section 21.1 has no application.
That is correct.
Sinenkani at the list, and definitely Ravens also in their own case.
Correct.
There would be jurisdiction to entertain their application.
Correct.
If that be the case, let's look at Sinenkani's case, where Kakamas Juventus has now been joined as the second applicant. I just want to understand what you are saying. If, for argument's sake, I'm persuaded by what Mr. Vobi says, I say, Sinenkani has established jurisdiction, I'm bound by the authority they rely on. Are you saying, I must say, yes, I will entertain that case? The first applicant, there is jurisdiction, but the second applicant must go to the Northern Cape High Court or must go to the Gauteng High Court on exactly the same issue. Because I understood Mr. Mhlanti to be saying, I align myself with what Sinenkani is saying, jurisdiction has been established. The reason we came to this particular court as Kakamas Juventus was this court was already seized with this matter. We didn't want a multiplicity of actions relating to the same decision. We are here to avoid conflicting judgments and multiplicity of actions. He says, if Sinenkani has jurisdiction, we simply are piggybacking on them that you are already hearing this. We don't want to reinvent the wheel in the Northern Cape or in the North Gauteng High Court.
Otherwise, we understood Mr. Tlati the exact same way or not.
Yes. So you are saying,
From that,
even if I were to be persuaded to allow Sinenkani to be here, I have jurisdiction, I must tell Mr. Mhlanti, who we will get to it immediately after the ruling, would be entitled to be a respondent as one of the parties taking part in the national playoffs, to say you can come in this case as a respondent, but you can't come in as a co-applicant.
my lord, arising from our mutual understanding of Mr. Tlanti's case, the question that arises in my mind is whether those two reasons which he advances for being here can be used in law to found jurisdiction.
Oh no, I'm
In
saying
respect of his attack.
just for present purposes, let's move from the premise that Mr. Vobi prevails. I'm persuaded by what he says. My ruling is, I have jurisdiction to hear this with respect to Sinenkani. They are feeling the effect here, paragraph C, same, they qualify in terms of paragraph D. All that I want to establish from you is, if that be the case, must I say to Mr. Mhlanti, you go to the Northern Cape if you want to be an applicant, or you go to Gauteng North if you want to be applicant. Essentially, to raise exactly the same issue that is already before this court.
I was going to say, my lord, about that. Ultimately, it's neither here nor there. Because if Mr. Kennedy succeeds on the point of jurisdiction and ultimately succeeds on the substantive relief, on the merits, the effect will be the same as far as Mr. Mhlanti's land is concerned. The reason we raised the question insofar as Kakama's Juventus is concerned is because, and before I did this, I had a proper look at the notice of motion. It's the danger of the cost order that they seek against us. So, and it remains.
We can't decide jurisdiction based on cost.
No, I mean ultimately.
When we get to costs, you may then raise the issue that, strictly speaking, although Mr. Mhlanti is here, he ought to have been somewhere else, a different cost order would apply, different to what Mr. Vobi is saying.
On that basis then, my lord, I'm comforted and I will take it with me. As the Lord pleases.
I'll just take a brief, no more than 10-minute adjournment.